All right, welcome back to our class on the physician-patient relationship and duties. We're now going to start talking about, I hope you enjoyed the video from Dr. Verghese. I think that's an important aspect to medical practice and should be at the basis or the foundation of every physician's commitment to provide care and the standard of care to each and every patient that they treat. Now let's talk about, and this is sort of a side doctrine or part of care that developed from that fiduciary relationship that physicians feel that they have and take very seriously with regard to their duties to a patient. Out of that grew the corporate practice of medicine doctrine. It's very fundamental doctrine to the structure of American healthcare delivery system. What the corporate practice doctrine does is prohibit a corporation or entity from practicing medicine or employing a physician to practice medicine and collecting the physician's fees for that practice. So it won't let a corporation hire a physician and bill for the physician and then the corporation keep those fees. That would prohibit the corporate practice of medicine. It's a common law doctrine, but it is now generally codified in every state's Medical Practice Act. The Medical Practice Act is the law in a state that governs physician practice, including the requirements for licensure and the requirements for practice, monitoring and disciplining of physicians and so forth. Most states' Medical Practice Act will make it a criminal offense to practice medicine without a license. The rationale for the corporate practice of medicine doctrine is that corporations, if they were hiring physicians to provide care and then collecting those fees, that the corporation could become more concerned with earning a profit, i.e. with the bottom line of profit, than they are about the proper care for a patient, and that physicians would not do that. Now, there's been some scrutiny over the corporate practice of medicine. A few states have abandoned it, but most states still do have an active corporate practice of medicine doctrine in their Medical Practice Act. The scrutiny is that it was never really proven that corporations would do that more than physicians would do that loyalty and doing the right thing should be key in any healthcare relationship. But there was a thought that the physician is face to face with the patient generally, forms a bond, forms a relationship, whereas in the corporate office, they're like responsible for the overall care of the corporation, hospital entity, whatever it might be, and do not know the patients on a one-to-one level. There was a thought that corporations making decisions about medical care would undermine the physician's professional judgment. The physician may say, this patient needs these, 10 tests, and the corporation may say, no, we think they only need 3 tests. We don't want to, expend the money for 10 tests. We think that 3 tests is enough. Where the corporation is not in a position to make those types of medical decisions. And that a corporation doing these types of activities would really subvert the physician's loyalty to the patient, that the physician would be bound to a higher level to the corporation that was their employer than they are to the patient in providing the proper patient care. That was the theory behind the corporate practice doctrine. Again, there's been increased scrutiny, and there's a number of exceptions. The exceptions have been somewhat due to the scrutiny, but also due to just in our age of managed care and looking at quality metrics and data-driven care, that's often best done in a network of both physicians and hospitals and other healthcare providers, so that there can be quality metrics. Everyone can look at data, use technology to determine what works, what doesn't work, look at standards of care, standards of practice, clinical care guidelines, evidence-based care. So that is best done in a managed care setting. So for managed care purposes, the corporate practice of medicine doesn't work as well as it did in the traditional form of a physician just providing their own care without regard to data-driven measures and what the network and the hospital system and other physicians were doing. Another exception has been for public hospitals. Public hospitals are any governmental hospital that's required to take care of the constituents in their jurisdiction, or generally the residents in their county, or if it's a hospital district, it would be within regard to the area that their hospital district serves. And that those public hospitals do not have the right to turn anyone away, and they have to provide care to all of the people that are within their that are their constituents, if you will. And so that public hospitals need to have some relief over corporate practice of medicine and be able to balance providing the care. They oftentimes have been allowed to actually employ physicians to provide that care, whether it's at the local level, whether it might be at the state or the federal level. The other major exception has been for physician-owned or governed organizations. And different states have done different things. But for example, in the state of Texas, that is one area that Texas has gone to. It's in the Medical Practice Act. We call it 162B organizations. But an entity, for example, a hospital or some other type of healthcare entity, can form a 162B organization. That's just where it's codified in the statute. But they can form that organization that can hire physicians, employ them to go and provide care, bill for their services, pay the physician a salary, and collect the fees. Sounds like it's in direct violation of corporate practice of medicine. But the caveat there is that the 162B organization, or the physician-owned organization, has to be governed by physicians, so that the governing body, either the owners or the governing body, have to be all physician. It has to be physician governed, so that it's at least physicians that have authority over the physicians within their organization. So it's not lay people or a lay organization, it's other physicians. Now, that doesn't mean that the 162 governing body automatically becomes or has liability for those decisions of a physician, but they control the type of practice, such as, when you have to take call, when you have to do this, what evidence-based practice guidelines you need to follow, those types of things. We'll switch gears a little bit to another area that's, I think, important to understand, and those are the legal obligations of the treatment relationship. This relationship that forms such a close bond between physicians and patients that provide an ongoing duty and obligation on the physician's behalf to the patient. There's many legal duties or obligations that come out of that. One of those that's very important is confidentiality. And it's based on the physician-patient privilege that's generally going to be codified in a state's Medical Practice Act. Now, the physician-patient privilege existed long before HIPAA, which is I always forget the official name, the Health Insurance Portability and Accountability Act, which was enacted in 1994. But long before HIPAA and requirements of patient privacy, there existed a physician-patient privilege, confidentiality, in every state that I'm aware of. That privilege would say that any communications between a physician and their patients and the medical records that documented that relationship and the care that was provided, everything in the physician's documentation and medical records was confidential and privileged from discovery, unless the release or the sharing of that record or those communications was authorized by the patient, generally in writing, with meeting certain requirements. Again, those requirements and how that authorization would work would be governed by the state medical practice laws, or an exception exists. And most of the physician-patient confidentiality privileges do have certain exceptions to allow for healthcare in general, often public healthcare that needs to go on, such as governmental agencies for reporting requirements. I mean, there's certain things that your public health officials are going to need to know. Communicable diseases being one of them, which we've all recently had experience with the COVID-19 crisis that our country has been in, is understanding the reporting requirements and the coordination with the public health or state health departments, so that they can, provide guidance, help with care, follow tracking of patients, and so forth. Those kind of exceptions have always been in existence. In addition to billing and other treatment operational purposes, there's got to be certain information that's passed on to the payor so that they have adequate information to pay the bills of the physician or the provider seeing the patient. for treatment purposes. For example, if the physician needs to send certain information to a laboratory for assistance, if the physician needs to get additional healthcare providers involved in the patient's care, then those individuals can have access to the patient's medical information to the extent that it's needed for them to provide their care and their expertise. Another one is for court proceedings, but in general, when we talk about court proceedings, the patient's medical record information has to be relevant to the proceeding. So a subpoena is generally in most jurisdictions not going to be adequate for whoever's issuing the subpoena to get the medical records. In addition to the subpoena, there will either have to be an authorization by the patient, or they will have to show that either another exception exists, there's a court order, or a court has made the determination that the records are relevant to the court proceeding. So those are the types of things that have longstanding been the requirements in the physician-patient confidentiality and privilege arena. Physicians also have a responsibility to safeguard a patient's medical records, and the physician or someone in the physician's office or practice becomes what's known as the custodian of those medical records. There are certain retention requirements, and again, that's on a state-by-state basis based in the Medical Practice Act laws. And then there's certain documentation requirements. To give you an example of that, I represented a physician at one point who was treating a patient who was also a close personal friend. And the friend came in to the physician's office and said, "Hey, you're treating me for this condition, and I know many of the people in this office. I also know we have many common friends, and I don't want you to document much about this relationship or my care in the record. Please just document the very bare minimum so that my health care doesn't get out there to all of my friends and people in your office practice and so forth." And in a lapse of judgment, the physician agreed to do that rather than reassuring the patient that, no, we have processes in our office to safeguard your records and your information. The physician said, "Okay, fine, I will only document the bare minimum." Well, as fate would have it, the patient developed some problems in the course of the treatment and ended up filing a lawsuit against the physician and filed a complaint with the Texas Medical Board. And in the medical board complaint, and also an issue in the lawsuit, was that the physician failed to meet the standard of care in documenting all of the care that was provided, the reasons for the care, and so forth. At least in the board complaint where the medical board looked at the physician's practice, they said, yes, you did not meet the standard of care, and you had a duty and an obligation for this patient to document thoroughly the problem the patient had, your recommended treatment, the treatment that was provided, the impact of that treatment, the evaluation of that treatment, ongoing care, and so forth. And so the physician was sanctioned and had to pay fines and had to do some remedial care and education on documentation in that situation. So there's a very strong commitment by the state boards and also under the law and a legal action that the physician has to meet certain standards in documenting the patient's medical records and in providing that care. Another legal obligation that arises out of the physician-patient treatment relationship is consent. And we have two types of consent. There's general consent, which we've all filled out. If you go into a hospital or if you go into a physician's office, you're going to fill out just some general forms that say, I agree to be a patient and to receive care and treatment. That is basically just to, prevent any allegations that the patient may later have to say you committed a battery, and it will cover things like, you can draw blood, maybe do some x-rays, do an examination of the patient, things that do not carry high risks of treatment. But when we get into risk inherent procedures or treatment, some drugs carry high risk, some forms of procedures carry high risk. Whenever we get to that type of treatment, then the law will impose what we call informed consent. And informed consent is a process by which the physician explains the procedure to be performed to the patient. The physician would need to explain to the patient their underlying condition here's the procedure I want you to have, or maybe the medication that I'm prescribing for you. And here are some things that may be done at the same time. I may need to do these additional procedures and so forth. So give the patient information on any additional care that may be needed. And also the physician would need to tell the patient the risks of the procedure. And there's different risk standards, but by and large, most jurisdictions have moved to a reasonable person standard or a reasonable patient standard. Sometimes some jurisdictions still have a this patient standard. What would this patient want to know? But that leads to arguments by the physician that this patient would not want to know that. They wouldn't want to know that, an infection was a potential of this particular treatment, or they wouldn't want to know that this could cause, bleeding. This patient wouldn't want to know that. So most jurisdictions have moved to what we call a reasonable patient. If a reasonable patient would want to know this is a risk of the procedure, then the physician has to inform the patient of that risk, any alternatives to the treatment being recommended, and then the consequences of not having that treatment or undergoing that procedure. And generally, states will prescribe what requirements have to go along with informed consent. It's going to need to be in writing in most places. And that just provides good evidence of the consent that was provided and given. Some states have some very specific requirements, Texas being one of them. Texas has an agency called the Texas Medical Disclosure Panel, and it is a group made up of physicians and lawyers for the most part. I think there are also some community members, and they will list procedures or surgical treatments, various other type of treatments that require a listing of certain risks. And so they're called List A procedures and List B procedures. They all need consent, but if it's a List A procedure, then the disclosure panel will list out the risks that have to be told to the patient. And then that consent has to be in a certain format that's very similar to what the state has a form. You either need to use a form that's similar or substantially similar to that state form if you're not using the state form. If you do that, if the provider or the physician does inform consent using that state form, and listing all the risks that the medical disclosure panel says need to be listed, then the physician will get a rebuttable presumption that consent was done properly. If all of those risks are not listed or it's not in the prescribed format, then the patient will have a rebuttable presumption that consent was not done properly. And those are often issues in medical malpractice claims or cases as to, well, I wouldn't have had this procedure if I had known that this was a risk. And then those types of informed consent requirements become very important on who gets the presumption or the rebuttable presumption that consent was done properly. So very important duty that arises out of the physician-patient relationship. There are limits to the duty. One is when treatment is completed, which we talked about earlier. For example, if you're going to a surgeon or any type of specialist, once the course of anticipated treatment is completed and the physician says, I don't need to see you anymore, then that treatment will be completed and there are no more obligations flowing from the physician to the patient because the original scope has been completed. It's important to be very clear about what that scope is, document in the medical records that this patient no longer needs to be seen in my practice, et cetera. If the patient moves to another, area, city, part of the country, transfers their medical records, it's presumed that that relationship is over at that point in time. Now, the physician may have an obligation or a duty to provide those treatment records to a new physician of the patient's choice and so forth. If the physician closes their practice, they will no longer have an obligation to the patient, but they do have obligations. And again, this is prescribed under state law as to how they have to provide notice to the patients that they're closing their practice, that they will no longer be providing care. Letters go out to patients, there's postings at the physician's office and so forth. If those things are not done and the relationship or the time period or the scope of the relationship is not just terminated due to the finiteness of the relationship itself, then the physician will actually have to terminate the relationship. The patient can always terminate the relationship, but if a patient says, I'm done, I'm not coming back to you, the physician really needs to document that in the medical record, make sure that they've clarified with the patient, this relationship's terminated, you'll no longer be coming to me for care, and so forth. And the patient can have argument, well, I terminated, but now I've changed my mind, so this is still within the time frame and you should still provide me ongoing care. So it's always better for the physician to formally terminate the relationship if that's the intent. Terminating a physician-patient relationship requires the physician to give reasonable notice and an opportunity for the patient to find another physician. Termination should be in writing. I always recommend that it be sent out certified mail, return receipt requested, and also sent regular mail, because many people won't pick up their certified mail. But if the regular mail doesn't come back, there's generally can be an assumption that the patient received it and received the notice in writing. If the patient's on site at the physician's office, it can be hand delivered, but there needs to be documentation that the letter was hand delivered to the patient. If possible, getting the patient to sign for even the hand delivery, the physician keeping a copy of that. In the letter, the physician can give any reason or no reason. Reasons to terminate may be the patient's non-compliance. It's just no longer become an effective relationship because no matter what the physician recommends, the patient won't comply with it, the patient argues with it, the patient does other things, and that it's just no longer feasible for that physician to keep trying to treat that patient. They may be better in another's practice where the patient syncs a little bit more with the physician's recommendation. Failure to pay, but again, there's got to be proper notice. Repeated no-shows, so that it's really interfering with the office practice of scheduling other patients, or having, holes or gaps where no patients are being seen during the day because this patient, continues to be a no-show, or no reason. And some providers, some physicians will prefer to give no reason at all so that the patient can't argue with the physician. Because some people will get their letter and call back and say, no, I'm going to completely comply now. They'll try it again. And, within just a few short weeks, the patient will fall back into noncompliance. So some physicians will find that it's easier to not provide a reason. Now, clearly the reason should not be based on discrimination or protected classes that cannot be discriminated against, such as race, gender, national origin, and so forth. If the physician-patient relationship is not terminated properly, then it can lead to allegations of abandonment, either a private cause of action. The patient can file a lawsuit saying, I was harmed, my condition deteriorated because my treatment was delayed, or the physician left me in the middle of treatment. I didn't get to continue treatment. And so I suffered harm from that. And it was caused by the physician abandoning me. Also, if the patient files a complaint with the physician's professional licensure board, then the licensure board they will look into it. They will look at the patient's allegations of abandonment. They'll look to see what documentation exists, what the physician says, or how the physician says the relationship was terminated, and what the evidence of the termination was, and whether there was proper notice. The general rule is kind of the rule of thumb that's grown up, is that a physician should give a patient 30 days notice. So from the time the patient receives their letter, they really should have 30 days that they can come in, at least for urgent care and treatment. They could come back and receive that from the physician. Also, it's important to realize that while a physician may terminate their relationship, a hospital doesn't have that ability to do that. And I often have physicians that say, maybe it's a physician that's on call for that type patient. Let's just say, for example, we'll use gastroenterology. And the gastroenterologist is on call for patients that come in through the emergency room. And a patient comes in and the doctor may say, no, I have terminated my relationship with that patient. Well, the physician may have, but the hospital can't do that. So if you're the on-call physician, then that patient comes right back into your practice, unless you can get another colleague that will agree to come and see that patient, or unless the patient says, no way, I do not want to be seen by that physician. I was terminated from their practice. I'm happy I was terminated. I don't want to see a new physician anyway, and get whoever. But if that's not a possibility under the on-call arrangement with the hospital, then even though that relationship has been terminated, then the physician is going to need to treat that patient, and then issue new termination at the proper time. One final thing that we'll talk about is duty to third parties that physicians may have, such as, because generally, again, it's a voluntary relationship. It's voluntary based on an implied contract. So if the physician says, hey, I agreed to see this patient, I didn't agree to treat this third party. But the law said, no, there's some situations where the relationship is so close to that third party, and that can be in the case of a third party beneficiary. For example, one of the best cases of that is for pregnant patients, and the unborn child becomes the third party beneficiary of the physician's treatment of the pregnant mother. Sylvia versus Gobil is an example of that. It's a case, you can read that to get more of an understanding of this third party beneficiary type relationship. That was a case where the mother had, I believe, measles, and the requirement would have been to give the pregnant mom gamma globulin. The physician did not do that, and the child was born with severe birth defects. And the court in that case reasoned that the child had a cause of action against the physician because the physician, it was foreseeable that if they didn't appropriately treat the mother for the measles by giving gamma globulin, that the child could have birth defects, and that's such a close relationship that the physician had a duty and the unborn child could bring a cause of action. Another area is when there's a special relationship, for example, contagious disease. The AIDS and HIV laws often will address this issue. At least in Texas, there's a specific law on providing this information, and when a physician can provide information on an HIV-infected patient to partners that have been identified by that patient so that they can receive proper testing and treatment. That's been not only in the AIDS and HIV, but really any form of contagious disease. Oftentimes it can be done through reporting to the state health departments, but sometimes there's a direct relationship. And in one case, the relationship was, I can't remember if this was that Hoffman-Backman case, but you can read that again to get an example of this special relationship and how the courts will treat that. But there was one that involved Rocky Mountain spotted fever, which is a disease that's transmitted through ticks. And the physician treated the patient. I believe the patient actually died from Rocky Mountain spotted fever. And the physician was aware and had been told by the patient that their significant other, I can't remember if it was a spouse or who it was, but that they were also with them. And the physician didn't provide any kind of notice or warning to that patient, that the person that had accompanied the patient, that you need to be tested too, because this is often, this is rare, but when we see it in one person, it's often, impacted, and you've been in a similar situation, so you may have it too, and you need to be tested, and they didn't do that. I believe the second patient died, and their family members brought the cause of action, at least for that second patient, if not for the first as well. Tarasoff versus the Regents of the University of California is sort of the landmark decision on duty to warn. And you may have heard of this case before. It is a physician's duty to warn a third party that's been identified by a patient that patient intends to harm them. And this was a patient receiving psychiatric care and treatment that said, I'm going to go and harm or kill this identified person. And the court said, in that situation where this patient is dangerous, you have a duty to warn that third person. Now, Texas is not a jurisdiction that's adopted the duty to warn, but many jurisdictions have. So you'll need to know in your state where care is being provided, or if you're advising healthcare providers in your state, what the duty to warn is and what they need to do in that situation. You can see from some of these exceptions, the duty to third parties is very unclear. It's not the same in all jurisdictions. It always is a balance between the confidentiality to the patient and to keep the patient's healthcare related information confidential and privileged, And that's a balance with protecting the third party. So it's a very difficult balancing situation that's done differently in jurisdictions, and it's done differently. It's very fact specific based on the facts in the particular situation. There's often no safe course for the physician or for the provider on what they do or what they need to do in those situations. So it's a very difficult situation where the physician or the provider is often seeking guidance and expertise from health law attorneys or someone else in an organization that may have experience in knowing what to do there. So those are some of the basic principles. I think that's the last slide. Yes, it is. Of the physician-patient relationship. It's an important and an ongoing, again, basis that forms some of the duties for our whole healthcare system, such as confidentiality, informed consent, and so forth. The hospital relationship with patients is quite different, and that's what we will talk about in our next class, is how that differs, mainly based on statutory laws and licensure requirements, and how that differs from the physician-patient relationship. Do keep one thing in mind, that is, when I say the physician-patient relationship, and that's how these laws all develop, most of these fundamental points will apply to other types of independent providers, such as psychologists, counselors, various other independent providers, oftentimes advanced practice providers such as nurse practitioners or physician's assistants, just different types of providers. May not be a physician, but these rules would apply to dentists and to other healthcare providers. So they arose in the context of the physician-patient relationship, but they have now been applied and somewhat spilled over and become the standard of care for other independent providers as well. Thank you. We'll see you next class.